For the fifth time, Governor Mary Fallin is being sued over the way her office has handled an open records request. The American Civil Liberties Union of Oklahoma filed suit in Oklahoma County District Court on behalf of two organizations that have waited a combined 33 months for release of public documents from the governor's office.
Arnold Hamilton is the editor of the Oklahoma Observer, and Wes Bledsoe is president and co-founder of A Perfect Cause. Each have waited nearly a year and a half for the governor's office to comply with their open records requests.
In the middle of July of 2014, the Oklahoma Observer requested, under the Open Records Act, documents from the governor's office related to two executions.
That was the execution of Gary Thomas Allen on November 6th of 2012 and Brian Darrell Davis, executed on June 25th of 2013.
Both these cases were cases in which the Oklahoma Pardon and Parole Board recommended clemency. That's something that the Oklahoma Pardon and Parole Board does not do very often. So we wanted to know at the Observer what went into the governor's thinking.
Wes Bledsoe has pushed state government for years to take steps to enforce laws protecting nursing home residents and to get state agencies to enforce nursing home regulations. 16 months ago, he filed an open records request in the governor's office to see what had been done about his concerns.
Did the governor investigate that? Did the governor bring these people in and ask them? And remind you, we're talking about Terry Klein, who is her Secretary of Health and her Commissioner of Health, and we also have Director Ed Lake amongst that crew from DHS. So this goes to the top of these agencies.
The Oklahoma Open Records Act uses the terms reasonable and prompt to define when a records request should be complied with. Brady Anderson is legal director for ACLU Oklahoma.
In one open records request versus another, that can mean different things. It may not mean the same number of days or weeks in every case, but we are convinced it does not mean 18 months. It does not mean 2 years.
While Bledsoe's request has never been responded to, Hamilton's request did produce some documents recently.
We did receive, a couple of weeks ago, a package from the governor's office indicating that it had complied with our request. It included 4 compact discs with 41,697 pages, it says, of non-privileged and privileged documents.
But there was just one problem.
Executions that occurred or were scheduled in 2014. Our requests were for executions that occurred in 2012 and 2013. It just seems outrageous to me that we would have to wait that length a period of time to get that information out of the governor's office. It can't be that difficult.
The governor's chief spokesman, Alex Wentz, says it is that difficult, and he claims Fallin's office has released more documents than any governor in state history.
Since 2012, our office has turned over 357,000 pages of documents in response to open records requests.
But why was the Oklahoma Observer sent the wrong documents?
That's the first I've heard of Arnold's specific request, and I will look into that. That's a different issue if he got the wrong documents, and I'm going to bring that to the attention of our legal staff and find out what's going on there.
While the ACLU lawsuit represents 2 requests for documents, Executive Director Ryan Kiesel says their suit really means more than that.
If we don't act, if we don't test what the governor's office is telling us with regard to how they're going to comply with the law, then that becomes the custom, and frankly, that becomes the law.
And that may already be occurring. Joe Wirtz with State Impact and Dale Denwalt with the Journal-Record newspaper both requested documents from Attorney General Scott Pruitt and have waited months for a response. They tweeted their frustrations over the failure to comply with their basic open records requests. ACLU's Ryan Kiesel sees the Open Records Act as user-friendly, but increasingly, that is not how state government sees it.
Every time you've got this litigation, or almost every time, the governor's office does a document dump, right? So if you want to get your records responded, if you want your records request responded to in a timely manner, it's not a matter of relying upon state law at this point. It's a matter of lawyering up.
The 2015 state integrity investigation not only gave the state a failing grade for access to public information, it gave the state a score of 25 to the question, are citizens receiving responses to access to information requests within a reasonable time period and at no cost. And a grade of 50 to the question, is the right of access to information effective?